Okay.
Welcome to day 2 of 2022 SUBStrong and the third of 4 sessions in the Reading Between the Lines contract study track. I am Mark Cohn with Delta Drywall, sponsor of the contract study track. We provide light gauge steel stud framing, structural steel stud framing, engineered metal trusses, gypsum board taping, finishing and texturing, suspended drywall ceilings, acoustical ceilings, insulation, and engineered load-bearing structural metal studs. I apologize for the lengthy list, but I want you to understand that with the services we provide, there is design risk, and with risk, we need the tools to protect and manage the risk and the place we begin with is the subcontract. This session discusses design risk, disclaimers, and asks, will you take the bait? Subcontractors need to carefully review the contract documents to identify and understand the impact of design disclaimers. Because of the significant risk design disclaimers can pose, it can affect your bidding strategy. Why? This session explores several types of design disclaimers in subcontracts and what is known as the Spearn Doctrine, as well as how to manage design risk. This session is presented by Laura DePetro, attorney at Woods Aitken. Laura joined Woods Aitken in 2014 and is a partner in the firm's Denver office. She is a member of the firm's litigation group, working in the commercial litigation and construction law practice areas. This session is to be continued, so be sure to join Laura's colleague at 3 o'clock this afternoon for a contract study when design risk turns to express delegations that discusses the subcontractor's design risk and responsibility. So take it away, Laura.
All right. And I assume that if this isn't working, Deb will let me know. But as Mark explained, I am Laura DePetro. I'm an attorney, and since working at Woods & Aitken for about 8 years now, I've almost exclusively been doing construction litigation. And I've done a lot of contract reviews, finding the scope gaps, and in particular issues where our clients could be exposed to a lot of risk. I'm always looking for these sneaky design clauses and trying to edit them or strike them or craft them in a way to remove them and reduce liability for our clients. So this is an important topic I think we should all consider. I know you heard from Amanda and Abby yesterday about what's in your contract and what's not in your contract, and this is just a variation on that theme and getting more specific here. Today, we are going to go through what Mark said. We're going to have an overview of what are design warranties and what are design disclaimers, and why do we have these things and where do they come from. Design warranties are a big part of construction law and your construction contracts, and they can be used to your advantage. So we'll talk about how you're going to use design warranties. Then there are some limitations that are put on using design warranties by the court systems, and we'll talk through several of those. And one of those, which is the thrust of this program today, are design disclaimers. And we'll talk about effective design disclaimers, ones you should be looking out for, and ineffective design disclaimers. And then we'll do a contract review exercise or two. So feel free at any point today to type in any questions, and I believe Deb will let me know if you have any questions, so we'll take those as they come. So let's start off about discussing our design warranties and design disclaimers. Where do they come from? What is a design disclaimer? A design disclaimer is an attempt to offload liability from the general contractor, from the owner, to you and your firm. It can come in the form of many different things. You're not going to see a big blaring sign that says this is a design disclaimer. It could be stating that you have no right to rely upon the soils reports, or the owner information is only information. You can't rely upon it, or you have the obligation to investigate the site conditions and report any deficiencies or inconsistencies, or you can't rely upon representations made by the contractor or the owner. It can come in a lot of different forms, and so you have to watch out for all the different ways it could come. So one of the things we always need to be aware of is where the design risk lies. It can come in your contract, and you heard about that with Abby and Amanda. You need to know what's in your contract. If it might be in an express clause, it might be through a flow down clause. You need to know what the prime contract says to know if the general contractor has agreed to certain design limitations or design obligations that flow down through your scope. You need to have all the contract documents. Just like when you need the prime contract, you need all the design specifications that might apply. Those design disclaimers or design obligations could be buried in specifications. And then you need to figure out what the project structure or delivery method is. You can see here that I have the two most common that you might see out in the field. You have on the left your bid build, where you have the owner contracting with a designer, and the owner is then providing the general contractor the design, which is then flowed down to the sub. In that instance, the owner is typically wanting to disclaim its risk, and those disclaimers are probably going to flow down to you through the general contractor. On a design build, the design build contractor also is providing the design, and the design build contractor is disclaiming probably directly to you. So that's where the risk is going to come there. So you need to be aware of all these different avenues where your risk can come from. But before we can talk about really why it is we use design disclaimers, we need to talk about where we started. And the design warranty comes from a very, very old case back in 1918 called the Spearin case, which developed the Spearin doctrine, which created the owner's design warranties. And in this case, the federal government gave plans to Spearin, who was a general contractor on the project, to relocate a sewer. The government knew that the sewer that was going to be relocated was in basically a floodplain, but it did not alert Spearin of this. Spearin constructed the project, and then the sewer immediately collapsed after a flood. And when Spearin wouldn't come back to the project unless it got redesigned, it got terminated. The contractor sued for his contract balance, and the government sued for back charges because it had to hire a new contractor. The Supreme Court held for the contractor, and it created this implied warranty. The implied warranty is if an owner is supplying plans and specifications, they are warranting their accuracy, or sometimes it's called adequacy, and that if those plans are followed, they will result in a functioning system. In every contract, this is implied. You don't need to expressly state it. One thing that Spearin also outlined is what will not work. They describe general disclaimers won't suffice here. So if you want to disclaim design obligations, general disclaimers like the obligation to visit the site or review the contract documents, those aren't going to work. So Spearin gave us a little bit of guidance there. So Spearin, what it does is it sets up ways that we can use design warranties to our advantage as contractors. So we call this the sword and the shield. The Spearin sword is if you get sued for breach if you incur costs because of defective plans, you can assert a Spearin claim, or argue that Spearin, that the owner had, or the general contractor had, an implied warranty to furnish you adequate designs, and you can claim your costs. And I cite here this Big Chief case. In Big Chief, the contractor was given, it was essentially a differing site conditions case, but the government successfully somehow struck the differing site conditions clause. And but the court nonetheless permitted the contractor to recover under the Spearin doctrine for a differing site condition. You can also use Spearin as a shield if you are being sued for failing to provide work in accordance with the design, you can have a valid defense under the Spearman Doctrine that the designs were defective. And there are, those are pretty obvious cases. I referenced this Amelco Products case where the contractor followed the exact plans, provided the exact product, and it had a proper defense that it was not liable to the owner for cracks in the pavement when it laid its asphalt, after the asphalt started cracking. In this Fayette rebar personal injury case, I found this one interesting because the contractor was sued for injuries to a person. A person was injured as a result of defects on the project. It turns out the plans were defective, and the contractor avoided liability for personal injuries to this individual by saying it followed the plans and specifications to a T, and those plans were defective. So that was a sufficient defense using the Spearman Doctrine. Now, the Spearman Doctrine, started in 1918, like I said, and it was almost exclusively a federal doctrine. Now, where does it apply? It applies in almost all states, including Colorado. It applies on public and private projects of all usually of all types of project delivery methods. It applies to a lot of different kinds of claims, differing site condition claims, defective design claims, misrepresentation claims against the general contractor or the owner. It can sometimes afford you delay and impact damages if you suffer delays or impacts as a result of a design flaw. And it can be a product incompatibility claim. So for instance, if the specifications call for a specific product and the product is just not the right fit for the system, that could be a viable Spearman claim. This is in contrast to a defective product. If the equipment or the material ordered happens to be defective, Spearman might not always save you there. That's more of a manufacturer's defect as opposed to a design issue. Who is protected by the Spearman Doctrine? Yes, general contractors on design build projects, they are protected because they get the designs from the owner who get it from their designer. It's likely that subcontractors are protected on design build projects because they receive the designs directly from the design build contractor. There aren't a lot of cases on this yet, but it's a likely extension of Spearman. It is unclear if subcontractors always get the protection of the Spearman Doctrine of being able to use an owner's or a general contractor's implied warranty as to the adequacy of the design. And on the very right screen, I've noted several instances where courts have said, yes, it flows down. So the Fourth Circuit, which is out toward the Atlantic Ocean with Virginia and Maryland and North Carolina, South Carolina, they've said that the warranty flows down to subs. Iowa has said subs are third-party beneficiaries to the implied warranty. California, on the other hand, and Idaho have said no. You do not get the protections offered from an owner. Likely in a design bid build case, you don't get the protections of a implied warranty because you don't have a contract with the owner, and the warranty is buried implied in a contract. But there are limits on using these design warranties. What I would like you to assume, and if you get caught in this scenario, your attorney is going to advocate that you get the protections of the Spearman Doctrine and this implied warranty. But there are limitations on using the design warranties. So more and more and more, we're seeing Spearman and the warranties getting chipped and chipped away. And they're not always going to protect you, even if your contract doesn't have any disclaimer. There are ways that the warranties just will not apply. For instance, there could be unreasonable reliance or a duty to investigate. You could fail to follow the plans. The plans could be for performance specs. You could have a no damages for delay clause, and then we'll talk about these disclaimers and other exculpatory clauses. So one way you're not going to get the protection of an implied warranty is if you unreasonably rely upon information. So for instance, you have to rely upon the designs, you have to follow them to a T, but your reliance has to be reasonable. And reliance will not be reasonable when the design contains obvious, glaring errors, or they contain obvious ambiguities. And that's hard for me to wrap my head around, because if a design is ambiguous, it's how is that obvious? But if there are inconsistencies in the contract documents, one document says X, one document says Y, issue an RFI. Those are the kinds of instances where you're not going to get the protection of a bad design claim. So, but you are not expected though to go out and find hidden, latent flaws in the design or ambiguities unless it's sneaked into your contract. But that's not part of your unsaid obligations as a subcontractor or a contractor. You have a duty, though, to investigate and inquire about obvious ambiguities, inconsistencies, and mistakes. There are some kind of shocking cases on this. I referenced a Florida one. There was a $10 million claim raised due to an issue with access over the water, where in Florida, the project was in a marshy land over water, and the contractor incurred $10 million just getting access to the project. And it claimed the designs showed access roads, but the court found those access roads really showed an ambiguous design element because the access roads were not supported by soils on the side. So a reasonable contractor should have known that those roads really weren't accessible. So it denied the claim, even though it couldn't get access per the design. There's another claim out of DC, a $40 million claim due to excessive watering. Dewatering was rejected. In that case, the DC Transit Authority did 3 different soils reports. None of them were shared to the contractors or the bidders, and at least one of them showed instances where there was going to need to be 300 dewatering wells installed on the project, not shared with the contractor. The design suggested 60 dewatering wells. The contractor incurred $40 million due to excessive dewatering, and the jury said that the plans were ambiguous, that the contractor should have been asking more questions. Those are scary, to put it lightly. And what I think this is telling you is raise your hand, ask questions, be a pest, issue RFIs. Don't let those questions go unanswered, and do it at the beginning before you start down this $1 million cost incurring. All right, some other ways where you will not get the protection of a warranty, design warranty. You have to follow the plans. If you do not follow the plans, you cannot claim that the owner or the general contractor supplied you bad plans. And I put in here that this is what we call a causation issue. So in all contract claims, you have to show that you have a contract, that there was a breach of that contract, and that breach caused you damages. And so if the breach is that the owner supplied you bad damages, or the general contractor supplied you bad designs, if you didn't follow them, how were you damaged? There's no link between the bad design and your damages. So to show causation that the bad designs caused your damages, you have to actually follow them. It seems obvious, but there's enough cases out there that says otherwise. Another instance where you will not get the protection of a design warranty. The design warranty only applies to design specifications. And if you hear dogs, I apologize. Design specifications are those that detail the work to be performed, or they detail what materials are going to be used or how you're going to be doing your work. Performance specifications are more like a target. You have an objective to achieve at the end. It affords you a lot of discretion. That's why discretion is key. If your work and the plans afford a lot of discretion on how you meet your goals and how you achieve your end result, that is a performance specification, and you will not get the protections. You will not be able to argue that the owner or the general contractor breached its implied warranty. Often is the case, though, your specifications are going to be a mixture of these two, so it's hard to figure out whether or not they're performance or design or a mixture of both. Another way that you might not get the benefit of a design warranty is a no damages for delay clause. You might be impacted left, right, and center because of a design issue. You could have increased costs to go back and fix, redo, correct work because of a design flaw. You could be wildly inefficient and impacted with multiple MOBs to address an issue. You could be stacked with other trades. You could have extended general conditions with the project being delayed as new designs are being developed. But if you have a no damages for delay clause, those damages probably cannot be recognized. You probably won't get those damages, even if the design caused those delays. So now one of the last ways that you will not be afforded protection for a design warranty is design disclaimers. We're going to talk about what's an effective disclaimer and what's an ineffective disclaimer. So all design disclaimers are technically what we refer to as exculpatory clauses. And exculpatory clauses are clauses that avoid liability. So I have a handful of other types of exculpatory clauses: no damages for delay, consequential damages, limitations on liability that cap your damages. We see that a lot in design contracts, waivers of rights and payment rights, waivers of various warranties, indemnity obligations, and also design disclaimers. Each of these types of clauses need to be express and unambiguous to be enforceable. It's kind of like one of those, I don't know if you hear in the law the concept of you need to be given your Miranda rights, and you're going to ask if you want to waive your right to an attorney. They're telling you all those things so that you make a knowing, intentional waiver of your rights. The same concept applies here when you have these clauses that are going to be drastically limiting your contractual rights. They need to be knowing, in your face, expressed, very clear. So design disclaimers and other design shifting clauses. And I don't want to get this concept in your mind that all design disclaimers are going to say, there's going to be a heading that says, this is your design disclaimer. Here is where we're waiving the Spear and warranty or the Spear and doctrine. It's not going to say that. It's going to be buried in your contract, buried in the specs. It's going to be through tacit references to the soils report and your right not to rely upon them. But it's not going to be right in your face. But the key here is to determine, to have it be legally binding, the waiver or the disclaimer of your of the design warranty. It can be either general or specific, and as we talked, these things need to be clear. So specific is the winner if it's going to be an effective disclaimer. General disclaimers will not work. So here's some general disclaimers, and I have a list and we'll go through them. I still get nervous about these general disclaimers. The law has said these won't waive the design warranty that you get from owners and general contractors. I still get nervous about these. So your requirement to check the plans, that's too general. Your responsibility to provide a complete product or to complete your work, too generic. Warranties that your work will be free from defect. Not all these give me pause. That one, for instance, doesn't give me too much pause, but the obligation to perform document verifications, I don't prefer that. If I see that one, I usually like to tack on, that you don't have any design obligations, or put some caveats on some of these. The duty to satisfy yourself of the nature of your work and the conditions that you're going to be working in. That one gets a little bit dicey for me. That puts the onus on the subcontractor to go out and investigate to make sure everything is peachy keen. But in these instances, I want to make sure that you only have the obligation to find obvious issues at the site or obvious issues in the contract documents, not anything that you'd have to go, dig up the power lines to find like undiscoverable things that, would cost you lots of money. Clauses that disclaim responsibility for the accuracy of information provided to bidders. So generally, a disclaimer that says, I'm not responsible for the RFP or the information in the RFP. Some courts have said that that's too general. I would still be nervous about that, but it has been said to be too general to disclaim design responsibility. Statements like, these are instructions that are for information purposes, and they're just the best information available, that has been held to be insufficient. That still makes me a little queasy. Specific design disclaimers, here's where they are certainly effective and have been held effective in the past. If there are soil borings that have been provided, but they state they are not part of your contract documents or they're not for your use, that has been held by some courts to say that is a disclaimer. You have no right to rely upon the owner information or the designs that are resulting from the soil borings. Number 2, disclaimers stating that the owner does not warrant the subsurface conditions. Also another instance where you won't be able to maybe assert a differing site condition claim. Express disclaimers that identify that the geotech reports or parts of the design, if the disclaimer is keyed to a very specific part of the design, though, as opposed to what we saw before is, I generally say that you can't rely upon any information I provide you ever. If it's tailored to a part of a report or a part of a design, that is specific enough to be held to be an effective disclaimer of design obligations. Provisions stating that the owner does not guarantee the quantities and that the contractor has to verify them, that has been held to be a design disclaimer. Now, a lot of these you'll see deal with soils reports because most of the published opinions out there deal with differing site conditions. These are instances where language that have been effective in Colorado federal court. So language that says that the plans and the soil borings and the tests are for the convenience of the contractor. That is shifting design responsibility away from the owner and the designer. The information is not guaranteed, and you can't have a claim for issues with the soils. That is a sufficient design disclaimer in Colorado federal court. A copy of a report is provided as part of the contract documents, but it is for information only. This all came from the same case, but the total sum of these were sufficient to find an effective design disclaimer. Now here we're going to go through some quick contract exercises, what to look for and what you can do to address some of these tricky clauses. So here in this one, the problem is verifying the accuracy of the information provided. So these have all come from contracts that I've seen and addressed in the past. So this one, the subcontractor shall verify the accuracy, completeness of the design drawings and specifications, and promptly notify the contractor of any errors and omissions. Subcontractor assumes full responsibility for any such errors and omissions that it fails to bring to the contractor's attention. I do not like this at all. What's wrong with this? The the design is now on the subcontractor to determine whether it's accurate, sufficient, complete. You know, a subcontractor is not a designer with design obligations. This is an unreasonable shifting of design. The contractor sub, you have to notify if there's a design issue. You have to go out and find it. And if you don't, you're liable, or all of it falls on your shoulders when the design goes wrong. So what can you do? You know, I jokingly say ask for more money if you're going to take on this design risk. You can completely strike this clause, may or may not work, maybe won't work, or you can suggest some edits. So here's what I would probably suggest. I would strike verify the accuracy and completeness of. I just want you to reasonably review. And assuming that you've been provided all of the drawings and specifications, and only those that apply to your work. As it read before, you were supposed to review all the drawings and find all issues for scopes unrelated to you. That's unreasonable. I'm sure it's implied that it only applies to your scope, but why not be clear? We're going to limit this to your scope of work. And then you're going to notify the contractor only if there are readily apparent, patent, or obvious issues in the drawings as they apply to your scope. And then you only are liable for such obvious errors that you don't bring to the contractor's attention. That is far more reasonable than verifying and shouldering the risk of all the design and being liable for even non-obvious design issues. The problem here is the obligation to investigate. The subcontractor represents and agrees that it enters into this agreement on the basis of its own examination, investigation, and evaluation of all contract documents, as well as the nature locality of the site work and conditions and difficulties under which it will be performed. And it has no right to rely and not in reliance upon any opinions or representations of the contractor owner. The hardest part there is the last phrase, actually, your inability to rely upon any opinions or representations of contractor owner. Representations are going to include that could be interpreted to include all the contract documents representing to you what the contractor and owner believe is the basis for how the project can be completed. And if you have no right to rely upon that, you have now taken on the design risk, that the design is insufficient, inadequate, defective. So all the risk has completely been shifted to you. You have to go out and do your own investigation, and you have no right to rely. Now, again, you can try to strike this, or you can suggest some edits, or get more money. What I would recommend is that throw in the word reasonableness whenever you can. I want you to always be first provided all contract documents, so I added that language in. And then at the end, I struck and the no right to rely upon opinions and representations. I want you to have reasonably investigated the project, but only to the extent that certain conditions are readily apparent, patent, or obvious. You don't have to go do your own soils investigation or have a separate inspection of the existing building. You need to be able to just rely upon what's been provided to you and do a reasonable site investigation. This one, the problem is constructability reviews, and when it goes too far. The subcontractor shall prepare and submit shop drawings as may be necessary. Approval will not relieve the contractor of its obligation to perform within accordance with the plans and specs, nor the responsibility, and this is where it got uncomfortable for me, nor the subcontractor's responsibility for proper matching and fitting of the work with contiguous work. I didn't like that the onus is on the subcontractor to make sure that its work seamlessly folds into other work. A drywaller is not an electrical contractor, they don't necessarily know the ins and outs of each other's scope. They probably know enough to speak on it, but that onus should not be on the drywaller to know the electrician needs to get in here and rough and wire in a particular way. So that to me added in a layer of design, obligation, and control that a sub likely does not want. I would suggest edits to this. I would actually strike that language and just completely get rid of it. Again, here's another one where the issue is this provision gives the subcontractor no right to rely upon the information provided. In this case, the contractor is furnishing building information. And at the very end, it says that there is a constructive presumption that the contractor did not rely on such data, but is operating at its own risk. Obviously, that's problematic. You need to be able to rely upon owner and contractor furnished data. This is the basis for how you bid the project. This is the basis for how you're doing your work. It is, if it turns out to be inaccurate, you're holding all of the risk. So here I would strike this clause or suggest edit. So here's how I suggested editing this. It is understood the owner shall furnish to the contractor building condition data prior to signing the agreement, and in the event the drawing specifications contain building data, such data shall be a part of this agreement. You want to make sure that is expressly stated, it is part of your contract. Here's another one where the problem is issues with submittals. This was one that I was just reviewing recently, and this particular contract actually includes express delegation obligations, which we'll talk about with Sarah next session. In this one, the contractor, owner, and architect engineer are entitled to rely upon the subcontract documents the subcontractor produces. And this was part of the submittals language. It was the next paragraph in the submittals. When you submit a submittal, this is saying the contractor can rely upon all the information and that you are warranting essentially that that information is accurate. I would say that this is a heightened obligation or duty on a subcontractor when it's submitting submittals. I would want to avoid this heightened obligation here. So what I would have suggested in this instance was to strike this clause and say the subcontractor makes no representations that its submittals or shop drawings or the data makes no representations about it, and that the data is for information only and for approval by the only for approval by the contractor, owner, and engineer. It's a bit of a flip. So I want to put a disclaimer on the shop drawings, just like you're getting disclaimers from the contractor. Flip it around on them. And here's the same contract. There is an express delegation provision in it. So this one said, if the subcontract documents require the subcontractor to provide design services and to specify all design and performance criteria, the subcontractor shall provide those design services necessary to satisfactorily complete the subcontract work. So what's really the problem here? It says, if I have to do it, then I'll provide the services. The fact that it says if, and it's not part of like an express inclusions that says you have these design services and these design obligations, it could be a sneaky way to swoop in some design obligations through a flow down clause. Or if you're caught in a scope gap where a design needed to be provided for certain materials or parts of a scope of work and it wasn't. And the GC is going to come back and point to you and say, you had design obligations. The contract document said if it requires design services, you needed to provide it. Option here, I would get rid of this. I suggested some other language. The subcontractor expressly excludes all design obligations and responsibilities of which shall be coordinated between the contractor, owner, and architect and engineer. In the event of any conflicts, this exclusion and the provisions of this agreement shall take precedence. This is also, this is just harken back to some of the things you always want to do to avoid unknown design liability. Have express exclusion stated that you're not going to do any design obligations. Put an order of precedence that is beneficial to you. The scope of work takes precedence over the general conditions in your contract. Your contract takes precedence over any conflicts in the prime agreement or the specifications of drawings. Often you'll see it flipped where those take precedence over your scope of work. But what you want is your scope of work is narrowly tailored to you. And so you want that to be the last say on what your design obligations are, if you have any. So exclude it and try to get in a beneficial order of precedence clause. And it looks like I'm a little bit short, and hopefully that's a good thing for you all. And if you have questions, I'm happy to take them. But otherwise, you have some downtime as you see fit before your next session.
Thank you, Laura. So we'll have this recording available, in a couple of weeks. I think they have them all trimmed up, and we'll get them in the SUBStrong library, so it'll be a point of reference for folks as well. So thank you.
Thanks, everyone.